Hi, District Attorney's Office.
Hi, my name is Sean Floyd, and I have a 10 o'clock phone appointment with Assistant District Attorney Entwistle.
Sure, well, I'm going to put you on hold and let him know you're here, okay?
Thanks.
Yep. Morning, this is Bill Entwistle speaking.
Hi, this is Sean Floyd.
Hi, Sean.
Hi, I just have basically a quick clarification, I guess,
Sure.
and then a couple of questions. One will just take a moment to set up, a minute or two, and the other one's pretty quick. So the clarification I wanted to offer is that I'm not trying to avoid trial here with this case, in particular the disorderly conduct case. There are several police involved. I don't know how much really you've looked into things beyond what you've provided in discovery, but honestly, I would relish a trial in certain ways and being able to grill the cops on the stand over their lies, what I allege are lies, and can demonstrate are lies. I was instead. I'm trying to streamline the process. I want to save myself some unnecessary work and save the court's time and taxpayer dollars and all that. Plus, there's always a risk of a conviction, even if it's only a billion in a one chance. It's always a risk at trial. But in my opinion, this case is absurd. It's not even really malicious prosecution. Certainly it was initiated as such, but at this point it's just persecution. And ultimately, I'm basically pretty positive that it'll be dropped before trial. But I have to prepare just in case, obviously. So luckily it won't take too long. So whatever. But regardless, I just wanted to go on record that that's my position regarding a trial, and also with my prediction that the case won't actually make it to trial. But I guess we'll see. Um, and any comment on that?
Nope.
Okay. My question is, last time like I said, it's going to take just a moment or two to set up. Last time we spoke, you said that we fundamentally disagree about what the facts are and how the law applies with regard to this case. And I want to point out three facts which we don't disagree about. They are not in dispute. They all came from discovery, which your office provided. And like I say, I don't dispute them. So, and they are all facts which are directly related to the accosting with offensive words, which is the basis of the charge as stated by the summonsing officer in person to me, and as recorded on video and written in black and white in her report. So I'm kind of running with that. I sort of have to. Those three facts are as follows. The first fact is that summonsing officer, Trabuzio, who I guess is now Harriman, anyway, the summonsing officer, she also told me and wrote in her report that when I say certain offensive words, which I had just repeated to her out loud, she said that I am offending people and that is the crime of disorderly conduct. Her exact quote from her report was, quote, I then informed Sean that when he says those words out loud, he is offending people and that is a crime of disorderly conduct, unquote. So that's the first fact. Second fact is, now that I've finally got access to discovery, the full discovery, body cam footage and whatnot, I see that in that body cam, in some of the body cam video, I see this very same officer saying, and I don't just see it, I mean it is what's happening on this in the video. This very same officer saying the exact same offensive words herself to the alleged victim, out loud, in public, people clearly listening in the video right nearby, paying attention, meaning that she committed the exact same act herself on video within moments of summoning me for it, and she alleges that it's unlawful when I do it. The third fact is that this alleged victim then says, in response to the summoning officer saying those exact same offensive words that I was eventually summoned for, she says, he says, quote, "Well, that's not illegal. He can say all that," end quote. And then he goes on later in another video, or another video clip at least, that I was provided with, and he goes on to use essentially the same exact offensive words, again in public, people around, meaning that he committed the same ostensibly unlawful act on video and right in front of the officer who had just summoned me for it. And she doesn't take any action. She seems to agree. She doesn't, with his assessment that set that aside. The interpretation aside for a moment. That's what he says in response. And he goes on to use the exact same offensive words in public, people overhearing. Now, I would assert that those facts, especially the latter two, which I was just provided with, and most especially if taken all together, definitely tend to create a very reasonable doubt as to my guilt as charged. So my question is whether or not the state agrees with this assessment of these facts or not.
Well, I'm not going to dispute what's on the body cam and what was said, but I don't agree that by saying those particular, I don't agree with the. I don't agree with your conclusion that by saying those words in the context of the investigation that anyone else committed any same offense that you committed. So I don't agree with the conclusion that you're drawing. I'm not disagreeing with what the video shows.
Okay, so you don't agree with my conclusion is very specifically, you don't think that those taken together tend to create reasonable doubt as to my guilt as charged. Again, remembering the Trabuzio or Harriman, the summoning officer's quote, taken in the full context of those three facts.
No, I don't agree with that.
Okay. And then we're almost done. Question number 2 is, as you know, obviously I'm proceeding pro se, and I have the right, arguably a duty, to investigate these cases, in particular, at the one at hand. Now, the state is required to provide the contact info of alleged victims and witnesses for this purpose, among others, I suppose, and did so. So, my question is, does the state have any objection to me contacting the Wootons and asking them a few simple investigatory type questions, provided obviously that I don't indicate that they should change their testimony in any way or not appear at any proceedings? In other words, provided I don't violate the witness tampering statute, of course. Does the state have any objection to me doing that?
So the only reservation I have, and I don't know the answer, is that if there's a bail condition that prohibits you from having contact with them.
There's not.
That would be what would prevent you from having contact with them.
Okay, so since they're
you articulated accurately that you're aware that witness tampering and any conduct that's prohibited there, if you talk to them directly yourself, you may put yourself at risk there, but that's a judgment call you'll have to make.
Well,
in
now
terms of whether.
Go
Let
ahead.
me just finish my.
Sure.
To give you just a full answer to
Please do.
your question. If there's no bail condition or protective order or any other thing that is a court order that says you can't have contact with them, then I don't have any objection or any real basis for objecting to you contacting them.
Right. Okay. Well, I suppose I necessarily put myself at risk of any number of things at any moment, at any time. So if I do what I just said, as I stated it, as you more or less confirmed, that will not constitute me putting myself at risk of that, violating the statute, doing an act that would be in violation of the statute, and the statute is very clear about what the it takes to violate it. Yeah. So as long as I do that, because I am proceeding. In other words, I can't contact them through an attorney or a representative because I don't have said. I have to do it myself.
Yep. No, I understand that. Yeah.
Okay. That is my statement and 2 questions, and I have nothing further. So unless you have anything that you want to relay to me, I think we're done.
Okay. No, that's all.
Okay. I'll see you in court.